Hello and welcome to this edition of our In Conversation series. I'm Andrew Guile, a solicitor and a director here at Guile Law, and I'm with my colleague today, Luke Cowles, and today we're going to be talking about an issue linked to the Equality Act and issues of discrimination, and specifically the issues coming out of the case in Northern Ireland of Lee against TheAshers Baking Co. This video is not intended to be an all-encompassing trawl through the Equality Act and discrimination issues. We're really going to try and narrow down and look at some of the issues that are coming out of the Lee and Ashers case. But it probably still is helpful that we give some essential basics in relation to the Equality Act issues and discrimination issues that underpin the case, such that our discussion that we're going to have makes sense to people who might not have some of that essential knowledge already well
sort of versed,
assimilated. So Luke, let's start off with looking at some of the essential aspects of the Equality Act and discrimination issues that sort of underpin the Lee and Ashers case.
Yeah, exactly. So the Equality Act 2010, it sort of draws together a lot of legislation that was very much split before. You had the Sex Discrimination Act, Disability Discrimination Act, and before you had different sort of characteristics and different laws dealing with this, and the idea of the Equality Act, by drawing it together, it mentions about protected characteristics, age, disability, gender reassignment, marriage, and I'm looking at my notes, pregnancy, maternity, race, sex and sexual orientation. And it's the idea that setting out rights about sort of direct discrimination, indirect harassment, etc., and how people sort of, I suppose, interact with people within those protected characteristics. And this is how this case, the Ashers case, the Lee v. Ashers case, comes about. Now, when it comes to sort of direct discrimination, which we'll sort of deal in a bit more detail, because this is the sort of direct subject in this particular case, it's usually fairly rudimentary. Person A discriminates against person B because of that protected characteristic. Certainly ourselves as police action lawyers, stop and search is something that there's a balance between stop and search being arguably direct discrimination from the officer who sees someone of a particular type, let's say, and decides they look suspicious because of that type, let's say race in this regard. But then arguably there's also the indirect side of things where perhaps the policy is made and the policy looks nice and blanket, but perhaps it's going to, by the very nature of the policy, end up affecting certain types of groups of people more than others. So that's certainly...
for instance, you could have a policy just to have unfettered stop and search, to look for knives or whatever, a Section 60 authorisation in a certain area or certain roads, very confined areas within London, for instance, which would undoubtedly be targeting specific people from specific communities who happen to live within certain areas or something like that.
Exactly, and I think the issue with often discrimination, just from an evidential point, and certainly sort of a practical point from us, is it's sometimes very difficult to prove. Discrimination, if someone physically writes something down, says something which is, sort of at least objectively to everyone else quite clearly discriminatory, fine, brilliant. But otherwise, often it is something that's in the mind, and you can't always prove that certain actions were a result of discriminating against that protected characteristic. The person may well have done, but they may well be able to, at least on paper, show there was other reasons why they've done it. And then when it comes to sort of that balance of probabilities test, which obviously courts have to apply, it might be difficult to sort of prove for certain, or I suppose it doesn't need to be certain, nature of balance of probabilities, but trying to prove that that's the reason they did it. And so it goes beyond just, I suspect I have had my rights violated, needing to have that evidence. Officers, we know they're not likely to write in their pocket notebooks, stop this person because of the colour of their skin. No. That'd be brilliant if they did. That would make our life immeasurably easier. But I think certainly in this case it's a bit more clear, if you like, as to what the bakers claim as their reason, because they're quite overt as to what they say they.
Let's roll it back. Let's have a look at the facts and actually go through what happened in the case, and then we can look at what the courts said and what we ended up in this, with the court saying in the Supreme Court.
Yes.
So this is all about a cake.
It is.
So Mr. Lee, as I understand it, goes into the Ashers Bakery in Northern Ireland, and they have a service that they offer within the bakery where you can go in and you can have your cake iced with anything you want on it, including messages and what have you. And Mr. Lee went in and asked to have a picture. I'm not sure if it was a transfer or something like that.
It had a
Bert
picture
and Ernie.
of Bert and Ernie.
And underneath that was a slogan in support of gay marriage. And at that time, as the court found, for at least 12 to 18 months prior to this time, the question of gay marriage being legalised
that's certainly one of the things.
Was a political issue.
And certainly in Northern Ireland, it is different to us. We legalised marriage for homosexual couples already exists in mainland UK. Northern Ireland, it's still a live issue where obviously it's going to touch on emotions that much more, because I think even in the judgment it mentions in 2014 how an attempt was made to try and get it brought in and it essentially failed. So that sort of campaign, understandably, continues, and certainly that's where Mr. Lee's coming from in this regard.
So I think the two main characteristics, or protected characteristics, that were active in the Supreme Court are his political beliefs, his desire to
get the law amended,
to advance the political agenda that he was supportive of in terms of legalising gay marriage, and in relation to the fact that he was a gay man.
Yes.
I mean, of course, you could have someone going in and asking for a cake to be made like this who isn't gay.
Yeah, because lots of
people
still support it outside
that movement. Absolutely, yeah. So that's what happens. So he goes in, and I think initially they take his order, when Mrs. Asher, who comes to make and ice the cake, sees what she's being asked to put on it, she refuses, and they think they refund him. I think.
Yes. I think.
And then he brings the discrimination.
The suggestion is that, and again, I could be slightly wrong, but I do remember sort of reading either through commentary or the actual facts directly that the reason his order wasn't necessarily taken straight away was not to sort of embarrass him in front of all the other potential customers that might have been there, but also, there's a question of I'm not sure if it was necessarily the owners who took the order as well, but yes, later on a sort of telephone call happens from Mrs. Asher, if you like. She calls, or not Mrs. Asher, but sorry, the telephone call happens, and then that's when they reject his order and the refund is given.
Yeah. So he brings a claim, and in the two lower tiers of court, he wins. Both of the lower tiers, the lower and middle tier, find. So
county court, then Court of Appeal, win, and obviously it's appealed from the county court and appealed from the Court of Appeal again. Yeah, and
then they find themselves at the Supreme Court, the highest court in the UK. And they take a different view. So tell us what their view was.
Well, certainly, and also the view itself, it's a unanimous view. So 5 judges all unanimously agreeing, and we'll come to that in due course. But I think obviously that matters, because if it was, say, a split 3-2 decision, then that would have shown, even in this situation, certainly amongst those judges, there's a lack of clarity. But 5 judges all coming out in support of I suppose, the Mr. and Mrs. MacArthur, who the owners of the bakery, and the sort of dividing line comes down to, did they refuse to make this cake because of his sexual orientation, or was it that the message that he wanted on the cake, is that the reason that they were objecting to it? And putting it in sort of as basic terms as you can put it, if they had discriminated on the basis of his sexual orientation, clearly protected characteristic, direct discrimination would be present.
But as far as I can see from what I've read, there was no evidence advanced that Mr. Lee wasn't even claiming that they had. Well, he was claiming that they'd done it because he was gay, but there certainly wasn't any evidence put before the court to show that that was their mindset.
Yes.
There wasn't any conversation that went along the lines of, "No, I'm sorry, we don't make cakes for gay people." And he was never, I think, trying to advance that. He was just saying, "Well, as a matter of fact, I'm gay. I've
made an order.
I've made an order for a cake supporting gay marriage, and they've said no. So I think it's because they've done it because I'm gay."
Yeah. And I think obviously, later on in the judgment, which is not too common, they actually reference an American case, which happened to happen in that sort of time frame when they're sort of looking at the decision, and they distinguish it because in that particular American case, the baker actually, you've got a sort of a gay couple, celebrating their marriage, want a wedding cake, and the baker refuses to make a wedding cake for them, no matter what, and it is because, essentially he disagrees with, sort of gay marriage in that regard. So it isn't a question of, I will make you a cake, but just not with that slogan. It's a question of, I'm not making you a cake at all because of who you are.
Yeah,
and I think
that's clearly discriminatory.
Yeah, absolutely, and I think that's certainly one thing. And as I said, it's not too common that American situations are directly referenced in our own courts, if you like, because they don't actually have material or direct effect in that regard.
Yeah.
But it's I think an attempt to try and distinguish between what the issue is here, that's being argued, and what the issue was there.
I think it's often done because the thought process behind the decision is one which is easily extrapolatable.
Absolutely.
If there is such a word as extrapolatable.
We'll get that.
It can be used over here, quite respectably and reasonably in a different or similar context.
Yes.
But what this case really seems to come down to for me is the court looking at Mr. and Mrs. MacArthur's. Sorry, I called them Mr. and Mrs. Asher because it was Asher's Bakery. I think confused with names. They looked at their Article 9 and Article 10 rights.
Yes. So Article 10 being freedom of expression, 9 being in relation to sort of beliefs and religion.
Yeah, because the way that the Supreme Court sort of like took the facts of this case and just sort of like turned them round and said, well, actually, looking at it from the wrong point of view, what's really happening here is the bakery is saying, we don't think that we should be criticised for refusing to produce a product for you which has upon it a slogan with which we, for our own religious reasons, fundamentally disagree with.
Yes.
And we don't feel that your right not to be discriminated against and things like this it's not right to look at it from that point of view. What you're doing is criticising us for our behaviour, and our behaviour has been done for these reasons. And our behaviour in that regard has its own protections under Articles 9 and 10 of the European Convention. And so essentially what the Supreme Court is saying is that there's no evidence that they did do this discriminatory. They weren't refusing to make a cake for a gay person. They were saying, you can't force us, and we are not going to be forced to produce a cake with that slogan on it because we fundamentally disagree with it. And obviously at the time they had no idea probably of their Article 9 and 10 rights, but when analysed after the event, it can be seen that they are entitled to do that.
Yeah.
And one thing that I was reminded of when I read through the Supreme Court judgment is that Article 10 is there to protect your freedom of speech.
Mm-hmm. Yes.
And Article 10 doesn't specifically say that it is also there to protect your right not to be forced to say something.
Yes.
And yet this is a case, and there are other cases before, which do demonstrate that it can and it should be interpreted in that way as well. Mm-hmm. So at first glance, Article 10 might seem, well, how does Article 10 come into this? But this right to speech, of free speech, also can be looked at the other way, and it's a right not to be forced to say something that you don't want to say, and that's something which obviously the lower courts hadn't really taken into account. Perhaps they weren't addressed on it by the advocates. It's difficult to be clear, but
yes, exactly.
But it's an interesting case from that perspective.
Absolutely. I mean, just looking at paragraph 34, just so anyone following wants to look at the judgment, they can see where we're referencing it. It talks about this principle which they look at called associative discrimination.
Yeah.
Now, essentially, what associative discrimination is, what they're saying in this case, is it's the possibility that a person may be less favourably treated on account of another person's sexual orientation. So, for example, if Mr. Lee wasn't a gay man, he may well have been a heterosexual man, still support the idea of gay marriage, still be the one in the bakery asking for this cake, for this message as part of the celebration, as part of the party that they may or may not be going to.
Yeah.
And they may be discriminated, not because that they are gay, but because other people that they sort of support that message with may be gay, and so that's associative discrimination. And in paragraph 34, you've got Lady Hale, who writes the judgment. She says this was a case of associative discrimination, or it was nothing. And then sort of going towards the end of that paragraph, she literally says, in a nutshell, the objection was to the message and not to any particular person or persons.
Yeah.
And so certainly that's one of the issues that sort of comes out of it in regards to how, I suppose, Lady Hale approaches this particular situation. And you can certainly understand from an empathetic point of view. I think Mr. Lee, when he came out of the Supreme Court afterwards, talked about how he felt he had been treated like a second-class citizen in that regard. And certainly,
you can understand
we can understand that.
I mean, without a shadow of a doubt, you can understand that. But as I've referenced earlier in this video, there's nothing before the court. It wasn't advanced as part of his case before the court that they had actively, said or done anything that clearly showed that they were discriminating against him because he was gay.
Absolutely.
Of course, every single case is different, and we could easily conceive of lots of different cases where there would be evidence of that, and that would be advanced, but it wasn't advanced. And as a result, Lady Hale is, in my view, absolutely right that this case did come down to whether or not they were prepared to produce a cake with that slogan on it, regardless of who was asking for that to be made.
Absolutely. So when you talk about Lady Hale and how she's done it, she's ultimately taking the case and she's looking at just how the law stands. This isn't about whether they were right to hold that view or the sort of political decisions or viewpoints between, sort of gay marriage in Northern Ireland and whether that should be brought in or shouldn't be brought in. Whilst, of course, you can completely understand, the sort of surrounding background to it. This isn't necessarily, or it isn't at all really, about the merits of, Ashers Bakery and the stance that they took in terms of that political decision. I mean, just looking, for example, and these, I've got some notes here, which obviously is some of these sort of key bits that Lady Hale mentions, and she says, paragraph 35, it does the project of equal treatment no favours to seek to extend it beyond its scope. Some of it is just, sort of repeating, but in a positive way, again, just sort of outlining how the law works in a purely mechanical way. And I think that's what it comes down to, certainly when you've mentioned before about protected characteristics and sort of that very fine line between the message and the person. Again, sort of paragraph 47, the objection was to being required to promote the message on the cake. And again, that goes to, and certainly some of the commentators, sort of afterwards, you've had some commentators, I think Peter Tatchell, I think it is, he's a gay rights campaigner, but actually supports this decision because the difficulty is should someone who, for example, is refusing to do, essentially carry out that service because of that message that they profoundly disagree with, and I use the word profound because that's the word that Lady Hale uses, should they be under the threat of being sued as a result? Because essentially that's what's happened here. Now, I think the slight difference between this situation and future situations is future situations will have the benefit of this case to actually compare to. Lady Hale, the fact that she's referenced the American case largely demonstrates that it was a little bit of unknown territory. Whereas in the future, people can reference this case, which will be our own domestic law, and it will be innately a precedent in that regard. There are some issues, of course, as to how far will it be taken in terms of, you can imagine the arguments of to what extent does a message count as a political opinion, count as a belief, and to what extent are you then allowed to refuse it? And of course, you can understand.
Yeah, and as I mentioned earlier, every single case turns on its facts, and I've got absolutely no reason to believe that the MacArthurs didn't genuinely object to this on religious grounds. But it would be very easy for someone to say that and not necessarily, and for that assertion not necessarily to be genuine. But there's clearly an acceptance by I think all three levels of court here that the MacArthurs did genuinely and profoundly, noted, think that supporting gay marriage was wrong on religious grounds.
Yeah, they would certainly look at sort of your background to see if there is actually a genuine background to show that you had held those beliefs. You weren't just suddenly using it as a sort of smokescreen for something else.
Because of course, if you just take the facts of this case, and if there was, if that belief wasn't profoundly held, if there was doubt, if it was advanced that wasn't a genuinely held belief, then of course the evidence as it comes out, factual evidence, might start to swing back towards them having refused because he was gay.
Well, absolutely.
And it's almost like you're doing this, you're sort of like you're swinging backwards and forwards between what did happen here. So, of course, when you get to the Supreme Court, you're talking about issues of law, you're not arguing about the facts.
So facts are established at that point.
The facts are set, they're set in stone, and those were the facts of this case, and of course, like any case, this case has to be seen on its facts.
Yes.
But I always think it's helpful perhaps for people watching the videos to think, it could so easily have swayed back the other way, had there been some doubt about their religion, if they never went to church, or if they put forward evidence along those lines.
Exactly, because if perhaps up until that point there was nothing prior in their life which would suggest that they actually subscribed to those sorts of values, beliefs, then it would, I suppose essentially the sort of question would be, well, actually, are you essentially lying? You have discriminated. You're just trying to use an alternate sort of idea to get round, or essentially try and hide the fact that you had discriminated. And again, like you say, obviously, by the time it gets to the Supreme Court, the facts are set in that regard. So this isn't sort of re-cross-examination, if you like, or cross-examination of the people again, because those bits have been done at trial, and they're essentially taking those what happened as agreed, and then just mechanically applying it to, in this case, the Equality Act. Also looking at the ECHR, obviously, when you mentioned earlier about Article 9, Article 10. Obviously there's a lot in here, for anyone who looks at the decision about sort of the administrative side of how but largely
how it came to on appeal, and the Northern Ireland jurisdictional issues and stuff, which we haven't touched upon at all. They're not really relevant. The reality is it did get to trial. It did get to appeal.
Yeah, absolutely.
And we're here discussing it.
Yeah, exactly. And
is there anything else you think would be helpful?
I think
anything else you'd like to mention?
I think what's clear is once this judgment was handed down, anyone who decides to sort of Google it, if you like, you will see people from both sides of the argument debating this issue, and clearly, it is one that someone was going to feel. Obviously, in the nature of cases, there's always going to be a winner and a loser, if you like, putting it in those simple terms. But because of the emotive nature of it, it isn't just simply a money dispute, if you like. There is that sort of people having quite firm views either way as to whether this is a right decision. As I said, perhaps if the decision was 3-2, would have opened up a slightly different can of worms, and I'm sure you can imagine the next 10-15 years people sort of chipping away at different things as to what is a message that they are allowed to object to in terms of based on their life, and what things are perhaps you can't just use certain things as excuses. And again, when it comes to the protected characteristics, something we're not going to in this video, but it's there's the extension of adding extra protected characteristics in
Yeah.
the future and arguments of that as well.
Yeah.
And certainly, certain types of beliefs maybe as well. But for another video, a massive debate in of itself.
Okay. Well, we hope you found the video helpful. If you do, there are lots of other videos in our In Conversation series that you might also find informative. And if you particularly like it, then please feel free to share it. Thank you for joining us. Hopefully we'll see you again very soon.